Thank you, and welcome here. If you want to move up a little closer, we don't bite, or at least not that hard. Anyhow, welcome here. We have a good group here. Did you find Pradeep, by the way?
Oh, we didn't. I just asked the people.
Okay. We're trying to find them. What we want to do today is talk about disputes in mergers and acquisitions. And frankly, we're looking at it from a variety of different perspectives. Nagler Nassar will start us off by talking about a case study, give you an in-depth case study of a complicated dispute. Then Patrick will start talking about issues mostly related to M&A from a Brazilian perspective, which is actually, can you hear me okay? Yeah. Okay, good. And then maybe Pardeep, if he comes, we'll talk about M&A issues, M&A disputes from a South Asian and Middle Eastern perspective. And I'll finish up by talking about issues that they may not have addressed, or at least giving you more of a European, North American perspective on some of the issues. I'm just going to start it off with a couple of very general comments, and then we'll get into these as the morning goes on. First, and I'm going to ask each of the speakers to spend maybe 1 minute giving you a brief summary of their experience. Myself, I've been a long-time general counsel and in-house counsel, doing transactions around the world. The biggest company where I was working was called Alcatel, which was a supplier of telecommunications equipment around the world. In that context, I did lots of M&A transactions, and then I did that with smaller companies as well. And right now I am working almost exclusively as an arbitrator and mediator around the world, handling a wide variety of commercial disputes, including M&A disputes. In the context of M&A, I'm going to say there have been 2 or 3 general subject areas. One relates to what I would call closing balance sheet adjustments. In other words, adjustments to the purchase price that are made after the transaction is completed. That's when the buyer gets in and starts looking at the books and basically says, okay, the books, the company is what we thought we bought, and if there are any adjustments to the price, then the parties will agree on this. Oftentimes, they will bring an accounting firm to make the final calculations. So you can get a lot of disputes related to what should be the final price that is paid. Another big area of disputes is what's called representations and warranties. And representations are basically statements in the share purchase agreement attesting to the bona fides of the target company. For example, a very common representation is the financial books and records of the company over the last 3 or 4 years have been done and calculated in accordance with accepted financial principles. This is a very standard representation. Another very standard representation is this company has operated in accordance with all applicable laws and regulations. Again, a very standard representation. Warranties are a bit more future-looking, saying that, for example, that the company has the intellectual property necessary to carry out the business it is carrying out and intends to carry out. So disputes relating to the validity of these representations and warranties are actually very common. Related to this, most merger and acquisition agreements have what I would call indemnification provisions, saying that once, depending on the size of the transaction, once the claims exceed $1 million, then the buyer has a right to go after the seller for indemnification. oftentimes there are caps on the indemnifications. Let's say there's a 20 million cap, a $50 million cap. Again, these are heavily negotiated provisions, and here he comes. Anyhow, welcome. I'm giving the introduction now, so we're just getting started. And the final thing I wanted to say with respect to representation and warranties, and we're going to get into this, is over the last 10 years, there's actually been what I consider a major change in the fact that there's a big market right now for representation and warranty insurance. So there are insurance companies that are willing to underwrite these representations and warranties, and we're going to get into this. The third area of disputes related to M&A acquisitions is a bit different. It relates to the shareholders themselves and whether or not the shareholders feel aggrieved by the terms of an acquisition agreement or a sale agreement. And again, you can often find disputes related to this. Anyhow, I just wanted to give you a little brief overview of the subject area. Right now, I'm going to pass the microphone to Ms. Nassar. She's going to give you a little, tell you a little bit about herself and her work, and then she's going to go into what I consider a very good example of a complex acquisition where a number of disputes arose. Thanks. Go ahead.
Thank you, John. Let's skip the part about myself. And I don't have a LinkedIn, by the way. No, I don't have a LinkedIn. I'm very conventional, traditional. You hear me, you know me, you ask people about me. I've been in the practice for 40-something years, so, So basically now, I'm an independent arbitrator, and that's all what I have to say. Okay. I'll pick from where John,
You can hear her okay, right?
I'll pick from where John left. He spoke about the contracts for M&A are very complex pieces of like legal art craft. Like, the M&A lawyers take pride in their work. However, they are never complete as any other human endeavor, okay? I'm going to speak about, I don't know whether, let me start by explaining to you the transaction first, before going into the dispute and what went wrong with it. This was a petrochemical, big petrochemical project that was almost there. They concluded the company. It's a greenfield petrochemical. The company concluded the offtake and the supply of crude. They completed the EPC, and then they suddenly faced, in 2008, the financial crisis. They could not finance the project, but the project was ready there on paper. They had just to start the construction. And obviously, not starting the construction and not finding the money would have held them in default of several of their concluded contracts. So they looked for a healthy company to overtake them, okay, and finance. The whole point was to bring in money to finance the project and to bring in a big name that would make the banks at this critical time feel comfortable lending money, because the money supply was really tight at that time. They did find a very big company, a European company, to take them over. Let me explain to you the corporate structure of the acquirer and the acquired company. The acquired company was a Middle Eastern company with 3 or 4 corporate shareholders. There were no individual. The acquiring company was a European company with a lot of subsidiaries, affiliates, and they were in the process of establishing an affiliate in the country where the acquired company was for purposes of the sole purposes of acquiring the shareholders. They concluded 3 agreements. First, the non-disclosure agreement for purposes of carrying the due diligence, okay, on the acquired company. Second, the SPA, sale and purchase agreement of the shares of the 3 corporate shareholders. Thirdly, a loan agreement where there would have been, besides the finance and the acquiring price, a loan to finance the increase of capital in the acquired company. Okay, is that all clear? You wouldn't imagine where it went wrong. The SPA had what John just referenced, the price clause, which was subject to finalization upon a proper due diligence that would be carried under the non-disclosure agreement, the NDA. It had the reps and warranties that John just have stated about. The loan agreement was supposed to, once the transaction was concluded, would disperse money to finance the increase of capital. And these 3 agreements, fortunately or unfortunately, it's like depends from which perspective to look at it, did not have identical arbitration clause. And don't ask me why, I didn't draft them. But that's where the trick is. What happened is the following. The due diligence was carried successfully. They expressed interest, they put a price offer, and suddenly they started feeling the company that was going to be acquired, something was going on, because there was an application for a permit to build an identical plan in the same Middle Eastern country from the director, who was a director in the acquiring company, and he was going to be the director of the special purpose vehicle, and he already was a director in all the other holding companies. After investigation, they discovered that the permits requested were based on cut and paste documents that were subject to the due diligence. And here, the triggering point was not the reps and warranties, okay, but was the non-disclosure thing. And the acquiring company had to protect themselves because there couldn't be 2 licenses. If this guy, the director, would succeed in getting a license, their own license would be withdrawn. Because in the oil and gas sector, it is not like everyone who wants to do a refinery can go and do it. I mean, there are capacities for the sectors, and there are regulations in the sectors. So they decided to sue or to go to arbitration on several grounds. First, the breach of the non-disclosure and non-compete provision in the non-disclosure agreement. And of course, there is a fraud aspect to it, which is a criminal aspect, which is non-arbitrable in the Middle East, okay? But they decided that they will not gain, upon legal advice, they would not gain anything but putting the guy in jail. They wanted to stop the licensing, and they wanted compensation, because they lost opportunities by being in that due diligence. You imagine a due diligence or something like that takes from 6 months to 1 year. So, I mean, they decided wisely enough that they're not going to pursue the criminal case because it won't help them in protecting their own projects. And they decided to go to arbitration on basis of the non-disclosure agreement for breach of the non-compete provision, okay? They decided to go to arbitration on basis of the SPA for breach of reps and warranties. They decided to go to arbitration on basis of the loan agreement, on basis of failure to provide finance and what for the increase of capital. Here, the attorneys deciding on the arbitration had to sue under 2 different forums, SIAC in Singapore and the ICC. And they faced another issue about who to sue, okay? Because the parties to these 3 agreements are not identical. The non-disclosure agreement was signed between the company that was going to be acquired as an entity, corporate entity, and the representative of the group, whoever is the group. It's a group of companies. The SPA was signed between the group of companies and the corporate shareholders of the company that are going to be acquired. The loan was signed between one of the financial vehicle of the company that was going to acquire and the acquired company. So you see here. So who was going to sue? Was it the shareholders of the company that had the license, or was it the corporate entity? And who was going to be sued? Okay, which company of this group? And especially that the fault of the copy-paste was from the director. And they had a very heavy burden of proof to prove that this group of company really knew what their director was doing, okay? But lucky enough, the director was stupid enough, he applied for the license in the name of the special vehicle, because as an individual, you cannot apply for a license in the petrochemical field. And I think he was just lazy. He didn't want to form his own company, so he applied quickly in the name of. Here we face several issues. First, a multi-party on part of the claimant, the shareholders, and the acquired company, which is the Dow Chemical Principle. Most of all of you have heard about the Dow Chemical Principle, where it was established that extending the arbitration clause under certain circumstances is permissible. The company really wanted to consolidate all 3 arbitration into one, which was difficult because neither the forum was the same forum. They were all institutional, but they were not the same forum. And again, the parties were not the same. They managed to consolidate them in one arbitration. They first tried to consolidate them by means of appointing the same arbitrators in the 3 different forums. So basically, this is a way of consolidating arbitration. You know, you don't have a consolidation clause in the arbitration dispute resolution clause. You don't have an consolidation provision. So you go and sue in the 3 different institutions, but appoint the same tribunal, and then the tribunal will take a decision to merge the 3 arbitration. The problem here is that all the 3 are institutional arbitration. And then which 2 institutions will forego their vested interest in that? In fact, the ICC refused to appoint the same tribunal. So that solution was out of the window, okay? They decided to pick the institution that was cheaper to sue under because of the cost of the bulk was very big. And they decided to discontinue the ICC because it was the most expensive forum there. Okay, now we are facing bringing in parties that didn't sign the loan contract into the arbitration, because the loan contract was the one with the ICC clause. Okay, here we have, as I said, multi-claimant and multi-respondent. In fact, the case of multi-claimant, or what is better known in the arbitration field as the Dow chemical principle, is much easier than bringing in respondents, okay? Because, as simple as that, a claimant cannot lose anything but being brought in a case. He'll just benefit of the decision if the decision is out into his favor. Okay, especially if they express interest in being in, you know, you don't bring in a claimant despite of his own will. So the principle of consent or party autonomy, which is the underlying principle of arbitration, is not greatly violated. The issue is much more complicated, bringing in respondents, okay? Here, the group of company, so it was easy to bring in all the shareholders of the company that was gonna be acquired into arbitration. They all sued, and everybody knew from the beginning that the decision would be in their favor to be joined into that arbitration. The problem was, how would you bring in the group of companies that was planning to acquire, especially that is a big issue and big defense that the director did that on his own initiative and for his own benefit. That was more tricky, okay, or more complicated. And here we have several doctrines, you know, I don't want to repeat them. I mean, you have the group of company French doctrine, you have piercing the corporate veil, you have estoppel, okay? And I have to say, they were both brought in, and this was a decision that the award was challenged, but was confirmed by several Supreme Courts in the Middle East because they wanted to execute it in several Middle Eastern countries against the group of companies. It was the theory of mistake. The group of companies acted as one entity. The director was applying in the name of the SPV, so regardless of whether he had instruction or not, it's something that they can settle with their own director on basis of the fiduciary duty, and most probably in the UK. However, it was held that in such circumstances where one person is dealing in the name of the group of company and has authorization and is from them to act on their behalf, and is an apparent agent of this group, it is correct that you can sue the group of company as a whole and not the individual entities that signed the different agreement. okay? It was a humongous.
Could I ask you to let us know how it ends so we can get to the other speakers?
It was a humongous award for 360 million euros, and the claimant prevailed. And I don't know, I mean, if they ever were able to execute the decision. My role ended by the award. And my knowledge is that they brought the group of company to sign a settlement and forgo the license agreement, which was their main goal. Thank you very much.
Thank you very much, Nagla. That's, she was covering a great deal of information in a very short period of time, but it gives you a good flavor of how complicated these matters can be and what happens when you don't pay careful attention to making sure that your dispute resolution clauses mesh. And that happens more often than you would believe. Right now, let's go to Patrick, who will give us a little summary of the Brazilian and maybe a little bit about the Latin America situation, but he'll speak mostly about M&A transactions and disputes in Brazil. So, Patrick.
Thank you, John. Good morning, everyone. My name is Patrick. I am a corporate lawyer, a business lawyer for 25 years. And I'm here today to talk to you a little bit about Brazilian environment in M&A transactions. Could you help me? Well, first of all, I have to tell you that Brazil is an amazing country, a beautiful nation with nice people, but definitely is not an easy country to understand. And it's even difficult to explain it. So there's a quote, there are two quotes that we use to try to talk about Brazil for foreign people. And the first one is from Pedro Malan. He's an economist in Brazil. In Brazil, even the past is uncertainty. And that's true. That's true because when we talk about the legal system in Brazil, we have 2 years or 5 years that's a lack of safe. And maybe you don't know Pedro Malan, but maybe you know Tom Jobim. And he says that Brazil is not a place for the amateurs. And that's true, because I think that because Brazil is a country with huge social difference, we have a legal system that tries to cover it. And the legal system is in everywhere. And there is a specific characteristic in Brazilian legal system that it's a cheap to everyone access. It's different from Europe, it's different from United States, when you have an expensive system and you have to take a risk to go to the justice. In Brazil, that's not like that. As a matter of fact, you have a lot of tools to go without any kind of payment, any kind of fee, even if you lose your action. So what are the mainly legal pitfalls that we have to face? And why I'm bringing this issue here today? Because it serves for M&As projects or any kind of business that your client will make in Brazil. So labor laws, it's something that scares any kind of investor in Brazil. Because if you're going to Brazil and you're thinking in buying a company, you have to face this monster. That's really a monster. Because when you have labor relations in Brazil, we have a specific court that's labor justice. This is something ours. I don't know if you have specific courts just to discuss labor relations. And this is a court that's always in favor of the employees. So what Brazilian law says, that the employee has 2 years to go to the justice, and he has to ask for 5 years of any kind of labor relation. So this is an expensive deal in Brazil, and if you have hundreds of employees in your company, you always have a huge passive. And the other is tax laws. It's very, very difficult to explain to a foreign our tax system, because we have a lot of layers, we have a lot of tributes, we have hundreds of new regulation every year. So we have 5 years to discuss any kind of issue involving tax. And companies tax are a very, very difficult thing to understand there. So tax laws and disregard doctrine. We have another specific issue in Brazil, that the legal courts doesn't respect the difference between companies and natural person. What means that? If you are an entrepreneur in Brazil and your business is not going well, you have to pay with your own money, and it extends to investors and even foreign investors. So it's a very, very difficult thing to deal with, and day by day. Slowness and excessive steps of Brazilian justice. This is a very, very complicated situation, since we will talk today about the arbitration. And arbitration is not a tool that the Brazilian lawyers use every day, because all the arbitration ends in a dispute in the justice. So it's a slow and excessive steps that we have to face in Brazilian courts. And of course, all of this brings a legal unsafety. So Brazil really is not a place for amateurs. And I'm talking about lawyers, I'm talking about entrepreneurs, because we have the most hostile environment for companies. I can guarantee that. Every time that a foreign investor goes to the Brazil, he has a lot of surprises talking about legal, corporate environment, labor laws, tax laws, and a lot of things that you need to be careful. And even that, we have an impressive environment for business. If you see here, the first semester of this year was the top record of mergers and acquisitions. For 10 years, tech has been the sector most active in M&A transactions. In 2021, the total amount of M&A transactions was 60 billions of American dollars. And all analysts say that 2022 will be the great year in sector. So even with this hostile environment, Brazil is a nice place to do business. Right? That's it.
Thank you, and sorry for being late today morning. I'm good to see people turning up today. I'm Pratik Bagaria, and I'll be taking a few more minutes from you discussing M&A disputes. My area of focus is Asia and Africa. We do international disputes based in DIFC, Singapore, India, but the disputes are spread across London, USA. Those are the main seats, or Singapore for a matter of fact. The idea for today's presentation, since most of us here, I see are lawyers in the room, is to share experience, to share what kind of differences come in cross-border M&A disputes, when people of different culture, people of different systems get into relationships with each other and where we reach with it. I had a presentation, but I don't think it's up, so I'm going to just take a free fall and free hit and just have a chat with people. And I would love to hear more from you guys on your experience in doing the same kind of issues. I've structured my presentation in 4 parts. I want to walk you through the life cycle of an M&A project and tell you where we saw these disputes coming, either ourselves or from friends like you who we co-counsel very often in delivering these kind of international disputes. I think the first interesting dispute, which is of course not something which we're doing, but I want to get the room with me to understand what kind of disputes can arise in M&A, is the very famous Twitter saga. Now that's classic M&A dispute. As we see, those kind of disputes can come in quite early in the pre-negotiation time, where there is a term sheet and someone decides to tweet and announce that they're going to acquire a company. Now that's going to do a skyrocket effect on the pricing, that's going to change the basic ethos on which you are entering into a transaction, and some people just do it for the purpose of leverage because it's a hard negotiation at the end of the day before you close the deal. But that could of course lead to complications in the entire deal scenario. And that's only the beginning of an M&A transaction. An M&A transaction, more often than not, easily described. If it's an acquisition, it's a purchase of a large asset which you don't have too much idea about. It's like going to a shop and buying a product which you really don't know whether it would work or you would like or not. A merger, on the other hand, is somewhat like a marriage. And once you walk through that path, we know how many disputes can arise in the relationship. So just in the beginning of an M&A, as you see from the Twitter saga, a great example arises that disputes can begin right at the start, because it's the start of a new relationship, and generally it's between a big conglomerate or a small conglomerate or 2 big conglomerates, and there are a lot of lawyers involved in the entire process, which can of course lead to several disputes. But giving you from my own example and keeping this very global to try to reach everyone's imagination, I think the first deal which I found a very interesting takeaway from was a medical technology company which was basically based in the United States and Canada, being acquired by a company in India. Now, long story short, the clients cut cost on diligence. They cut cost on diligence of the IP. Now, when they cut cost on diligence of the IP, they did not realize that several of their patents had actually expired. It's a medical device company. One of the core asset for acquisition was the patent. And if the patent is not something which is with the company, there was no purpose to really acquire that company from US and Canada. This was a heart stent manufacturing company. They used to make valves in the heart stent, and a pretty sophisticated injection technique had been invented apparently by the company. But they bought the company with limited diligence. Now, the problem which arose for them is they inherited a bunch of litigation, including RICO litigations in the US. So originally they saved cost by doing limited diligence on the IP, but subsequently when they moved into and acquired the company, they realized that they inherited a bunch of litigations which were never disclosed, which they had to of course face and defend. And I think the client ended up running a bill of almost $6 million in just defending and getting them out of the proceedings ongoing, and then a few $1 million to prosecute the claim for mis-selling in the arbitration. And like Nagla pointed out, there were several issues here of non-joinder of right parties into the arbitration, or issues regarding who should be the real party. Is it the owner who sold it, or is it should be the company? But I think the point which it drove for me in an M&A transaction or an M&A dispute is, look, the core asset diligence is where we need to advise clients to spend time and money, even as an in-house counsel or a company who's looking to budget on how to approach an M&A. The core asset ought to be diligence, because that's where you're putting your money. There is no logical sense to cut cost in that field. Now, you can cut costs in various ways, but the core asset should be looked at deep, because otherwise you're looking at problems which are going to come in early in the relationship. I think the second interesting case which I want to discuss is something which may be known to the people in this part of the world because a long saga went in the Dutch courts for set aside of these proceedings, but it comes from a very famous case of Vodafone. This case eventually reached investment treaty arbitration as well. India was sued for certain tax consequences on this transaction. We were the ones who advised, in my old role, we were the ones who advised Vodafone to initiate the investment treaty arbitration. Now, the case was pretty simple. It was a classic tax structuring. Two companies, Hutchison SR and Vodafone, buying, selling each other in the telecom segment, massive deal, few $1 billion, but the actual sale was conducted in a single dollar. So they came up with a tax structure which was passed through, advised by eminent tax lawyers across the globe. And they said, look, we're going to structure it in this way that assets of a particular company are going to be bought for $1, and that's going to be where your taxation is going to lie on the M&A. Now, in those times, at least in the subcontinent, there was not really, as Joe pointed out, M&A insurance, right? People were not doing reps and warranty insurances. People were not taking tax indemnities. Those were unknown concepts till such big disputes hit the rock. So of course, this transaction had no reps and warranties on taxation. This transaction had no M&A tax indemnities negotiated. And what happened is, of course, India got pretty upset with the entire transaction. They said, you're selling an entire telecom operation in the country for $1, but when we know that you really are making few $1 billion, so we're going to change our tax law, and we're going to somehow make this transaction subject to taxation in India. And we often see this, that when there are big ticket deals, regulators come in, not only tax authorities, you see Competition Commission coming in. There's the famous Amazon saga, which happened a few years back on these kind of M&A disputes. But what came out from this entire scenario is you need to look at your taxation. And of course, tax lawyers are innovative, so you need to get indemnities when tax lawyers don't, when authorities change the law, or of course, the tax is not how it should be. And tomorrow you need to face liability. Because again, like in the case of acquiring core asset, if your taxation is incorrect post-acquisition, the value of the asset will not remain what you accounted for. So the business is never going to be happy with the asset coming in the hand, because today it would be costing them X, it would be X plus 10 in a few days later. So I think that's the second kind of dispute which was very interesting for us to be involved. I think the third one, talking about the Middle East and just coming out of a hearing on it yesterday, pretty fresh in my mind. It's a post-M&A dispute. This comes out of the Qatar blockade. One of our clients was exiting. Many people you see in Qatar, several people had to exit business during the blockade. They had to sell assets because they couldn't hold assets in most of the part of the Middle East. So this is a Qatar blockade sale, got done in 2018, 2019, our client's expecting around $115 million to be paid to him after the transaction is over, receives 23, and then he doesn't receive any more money. So this is a non-payment case in a post-transaction scenario. Unfortunately for him, COVID-19 hits a few days after the Qatar blockade ends, and after that, of course, everything is down south. He keeps extending the payment schedule, hoping he's going to receive the money, only eventually to realize that he's been defrauded into the transaction. The person who acquired the company sold it through an offshore structure to another company where he dwindled all the money and took it away. That, of course, led him to a series of litigations. We filed proceedings in Cayman Island, we filed proceedings in Singapore, we filed proceedings in DIFC, and we are doing an arbitration in London. Long story short, because he did not use an escrow mechanism and because he did not use any safekeeping mechanisms, he had to go into big litigation. The only thing his team negotiated for him was a security, but a security, as we know, leads to so many litigations to enforce. And we are in a big battle for this case. The client is looking at least $4 to $5 million of legal expense just before he reaches the final outcome. But since there is so much money to take, he has no option but to do it. But I think the takeaway from me again, from this dispute, is don't save money on escrows. They are expensive upfront, they appear to be expensive upfront. But the minute you have a third party who is taking care of inflow and outflow of money, the ability to trust someone is higher because they are fiduciary service providers. Their business is to provide trust to you. So rather than vesting your trust in a deal or a person you're getting into a deal with, the better approach is to take third-party service providers, especially in high-stake M&A disputes. Because these small costs, when you add to the deal, your deal would be $50,000 more. But what you saved from taking these steps, if you take a good escrow, if you take a good indemnity insurance, if you take good diligence, okay, you may go higher, $200,000 more. But what you would save is a lot of headache later on. What you would save is a lot of dispute later on. I think the last kind of dispute which I would bring in is, of course, the very often disputes in which we call as exit disputes. In many M&A transactions, you keep the acquired party for earnouts. So you tell them you stay in the company, we're going to pay you X money today on basis of your performance, you're going to make a particular earnout, and then you're going to exit the dispute. Now, this one was a very interesting pharmaceutical case which I was involved in, a big pharmaceutical company acquiring our client somewhere in Israel. Now, it was supposed to be a US FDA approved plant, manufacturing fantastic product, top of the shelf, and the company was looking profitable. The seller negotiated an earnout on the basis of performance of the company in 3 years. And what he ended up doing is he agreed to a particular business plan which made him give a particular EBITDA return at the end of 3 years. Now, when you fix your EBITDA return in an earnout, how does it affect a buyer or a seller is something what I learned from this dispute. Today, when you're manufacturing 3 medicines in the same factory line, versus if you start developing the factory to manufacture 6 medicines, which would be available after 5 years, there would be a massive difference in the EBITDA you make in 3 years. What he didn't do while agreeing to an EBITDA is he did not cap the capex, which could come in the company. So while he was expecting certain profits to come in, because the capex increased, and of course the buyer knew that he could do that and only delay profits by a few years, on the day the earnout was due, the company would be making significantly low EBITDA because the capex line was still continuing, but just after the exit date, he would be making significantly high profit. In this way, he would shortchange the acquired 3 years later, buy him again for very cheap, and then eventually make profit immediately after the buyer leaving. Again, this led to a huge SIAC arbitration for the client. They had, unfortunately for us, agreed to a 4-month arbitration clause, which meant lawyers and their teams did not sleep. There were 7 witnesses on each side. There was a lot of disputes going on, expert witnesses on quantum, et cetera, et cetera. But I think the long story short in this is take financial advice in structuring your earnout. I know that a lot of commercially involved entrepreneurs enter the M&A and they think they are the numbers people. And they understand how CAPEX works and how EBITDA works and how the numbers are going to work eventually. Even the business in several clients' team, we've seen it, that they truly believe that they will be able to structure the right earnout for their own team. But I think a forensic look is always helpful. It is always useful while entering into an M&A transaction to see it from another lens, that how this can be manufactured in another way to change your outcome. So long story short, I think M&A transactions are like getting into a long business relationship or a partnership or a marriage. It's very useful to keep your eyes, ears open and to keep your pockets open while getting into these transactions. Thank you so much for your time and patience.
Thank you very much, Pratik. That was very good presentation, and I particularly was pleased that you went into the discussion of earnouts and what I would call contingent payouts, which are actually relatively common in M&A agreements. What I'd like to do now is I'll say a few words, but I want to raise some issues for the panel and actually for the audience as well. Because what I want to start off by asking the panel, we have heard from both Pratik and Nagla about arbitration clauses for dispute resolutions of M&A agreements. Unfortunately, I don't have them with me, but I have seen a number of studies recently. And in the United States and probably Western Europe, I'm looking mostly at the UK and France, it seems to be that most merger and acquisition agreements, most share purchase agreements provide for using local courts as the forum for handling dispute resolutions. I think in Europe, as you head eastward, there becomes there's a greater acceptance of arbitration, probably in the Middle East, maybe South Asia and Asia itself. There's probably even a greater acceptance of arbitration for handling M&A disputes. When you go to the United States, actually, probably, I think the most recent ABA study, American Bar Association study I saw on it, probably had about 15 to 20% of M&A disputes or M&A agreements being subject to arbitration as the dispute resolution clause. So what I'd like to do is ask my panel what their experience is in terms of what types of dispute resolution clauses you see in your practice. And frankly, people in the audience, please feel free to chime in and let us know what you're seeing, what trends you may be seeing, and what you expect. Let me also add another question to the, as well, as whether you are seeing any a greater use of mediation, or whether mediation is used in M&A disputes at all. So let me begin with Nagla.
I don't know if this is working. Just hold it for longer. Yeah. Well, it depends what type of M&A we're speaking about. If it's local M&A, like in a country, or a regional M&A between two Middle Eastern countries, or any two countries from any region, like Asian countries, or it's an international one involving people from different regions. In the first category, no, we don't see arbitration clauses. We usually, people from the same country feels comfortable resorting to their own legal system, which in most cases, besides this type of M&As, are usually the smaller type of M&As in terms of value. So, in respect of the regional one, there is usually a reference to dispute, because not that they don't trust each other's jurisdictions, but because it's usually the issue, whose jurisdiction should we go to? So they usually choose a regional arbitration center like SIAG or Lagos or Cairo Regional, or Dubai, or to solve their dispute. In international acquisition, M&As, definitely is arbitration. The issue of jurisdiction even does not come on the table. Mediation, from my experience, is not something tolerable in M&As. You know, when you're negotiating an M&A and you bring up mediation, you're gonna find the buyer panicking, you know, straight away. Mediation about what? I'm paying and you have deliverables. So you have to give me a company that meets the standards that are written in the SPA. So no, for mediation, no. It is not something tolerable in M&As.
I have my own, thank you. Well, in Brazil, it's not so different. When you have a negotiation between Brazilian companies, arbitration clause is not welcome. And nobody knows why this happened. This happened because the Constitution, the Brazilian Constitution says that there will not be any kind of issue that's not possible to go into the justice. So the Brazilian companies prefer to straight to the courts when have some kind of dispute, because the arbitration is very expensive in Brazil and completely uncertain. And every time that there is a decision, the loser goes to the court. So arbitration clause is not welcome between Brazilian companies, and the other hand is impositive when you have a foreign company going to Brazil. American companies, European companies, all of them impose the arbitration clause. So when a Brazilian company is being selling, we have the arbitration clause, and any time this arbitration happens outside Brazil. So it's not a mature dispositive yet in our country, and mediation is the same. So the Brazilian justice always goes straight to the contracts. It's not an ordinary tool there.
I'm going to differ. I'm going to differ with my. I'm going to differ with my audience members on my experience, because, at least in my part of the world, especially Asia, we see arbitration in every M&A contract. A large part of M&A contracts, be it international or domestic, are arbitration. A lot of people in the jurisdiction, like Korea, Japan, China, India, would take their disputes to Singapore. We see a lot of these M&A disputes of various forms being resolved in Singapore. Same for mediation. I think mediation is big in M&A disputes. I recently came out of a SIAC ARB-MED-ARB dispute, where you start the arbitration to move into the mediation, chalk out certain issues which you can resolve. So take, for example, in an M&A dispute, out of the 15 things the promoters are on their throats with, 12 can be sat down and rolled out on the corner, and 3 can be fought about. I think it also depends on the opposite side lawyer and what his brief is, right? If he's someone who's there to resolve the dispute, I would like to chalk out issues which are resolvable. We don't need to go to trial for them. Sit in a room, knock them out of the park. There will be open issues to resolve, and they may go into arbitration. And we see a lot of streamlined process to achieve that in that way. But I think neutrality is the...
Can I ask a question? They go to arbitration even if they're from the same country. I'm not saying from...
Same country. So if you say a big
mistrust to the legal system, legal system.
I think it's not a mistrust to the legal system. There's a huge degree of confidentiality and speed which comes in with arbitration process. And especially, say you're doing a big acquisition of 2 conglomerates, say, in the region, if I had to name, say, a Reliance with someone in the Middle East, Petrofac.
That became international.
Let's do domestic. Reliance with, somewhere in another part of India. They would always choose an arbitration clause, because no one wants to go to court with their dirty linen, right? It's pretty much open. It's going to be in the media and news. Arbitrations also reach media and news today, but not at the extent a court litigation reaches. Also, I think one benefit which people see is enforceability, right? Even if you're in domestic disputes, even if it is 2 parties you're fighting, it may not be necessary that you need to recover from within the country. Most international businesses, or most Indian businesses today are international. Most Asian businesses today are international, with an asset profile which is pretty global. So if you have to take a decree to recover, you may be seeing assets sitting globally where an arbitration award is enforceable in 180 countries versus a court decree which is just between that region. So it totally depends on what kind of transaction it is, I get, but at least I would say 90% of M&As in the region, Southeast Asia, a large part of Africa, Nigeria, where we've seen work, Somalia, Rwanda, we've seen arbitration clauses pretty much as a regular theme.
Okay, thank you very much. So there is not a unanimous opinion on the subject of dispute resolution. Does anybody in the audience want to join the discussion? A microphone is coming. And please introduce yourself.
Oh, okay.
And you
Hi.
can stand up so we can see you.
a little shy. No. My name is Liat Galiri Perel. I'm an advocate from Israel, and I basically mainly deal with IP. So my questions will be a little bit about IP. I have two questions. One for Patrick about Brazil, and the other one from Pratik. About Brazil, well, you make it sound horrible doing business in Brazil, and I hope that's not the case, because many of our big clients do have business in Brazil, and they have a lot of IP registrations. So I was wondering if you know how strong is IP protection in Brazil when it comes to disputes, litigation disputes. And my other question to Pratik, I loved your story about the IP due diligence negligence, and there's no other word except negligence for this case. Not sure the insurance even covers that kind of negligence. We provide a lot of IP due diligence for companies worldwide, and I was wondering, from your experience, how common is this situation with this IP negligence? Is this something you see a lot of mergers, acquisitions, having this kind of negligence? Because it's really simple to just go into Google Patents, and just write the company's name and see the status of the patent. I mean, you don't have to be an IP expert to do it, so thank you.
Well, you can trust in legal justice Brazilian. What I bring to this panel is that it's a hostile environment, but it's a confident place. So I think that we have enough tools to protect IPs and to protect intellectual property in Brazil. You don't have any kind of reason to concern about.
Coming to your question, very good question. So IP disputes in M&A come very often, and I know it's pretty easy to check IP, and I get surprised why they come very often, because I think there is an expectation mismatch always in the IP, especially the more advanced the technology, its performance, and where it leads you to, that makes a difference. How you sub-license it or you remanufacture it backwards make a lot of difference. So as you said, you rightly said that, of course, you can just go and check whether the patent exists. But what if you've given exclusive rights unregistered on it to someone else to do X, Y, Z in a particular territory, or to monetize it in a particular way which you don't need to register anywhere? So just seeing what is online sometimes is not available. In fact, the case I spoke about, what was very interesting, that even lawyers were suing for their unpaid fees of patent filing, and some patents filed mid-deal because they got into the deal checking it, but the seller didn't pay their lawyers, so the lawyer didn't file for an update, and the IP lapsed and someone else registered it. So a lot of things can happen. I think where you need to, and you rightly said, you need a strong team to diligence the IP before the acquisition.
Okay, thanks. We'll go Stefano, and then before you say, I just want to make one comment. Is I've worked a lot with private equity groups, and they do a lot of M&A transactions, and what they actually do very commonly are what's called vendor due diligence. So before they even put their company up for sale, they go through it like they were doing a due diligence themselves. A lot to guard against, things coming out of the woodworks. They want to be prepared. Anyhow, I'll stop. Go ahead, Stefano.
Yeah, hi, good morning, everybody, and thank you very much for all the presentations. My name is Stefano Catalani. I'm a lawyer and adjunct professor based in Geneva. I have a comment and a question. The comment is that I like very much the Southeast Asia approach. To be honest, and I think there's a growing trend also in Europe. I don't see any reason why you shouldn't use arbitration in M&A transactions, and I don't even see any reason why you shouldn't use mediation in M&A transaction. And I think the trend is in that direction. I'm not going to repeat all the reasons why it makes sense to use both of them, because they have already been mentioned, but frankly speaking, I don't see why there should be any resistance to go in that direction. The question I have is specifically for Brazil. Patrick, you mentioned that there is this disregard doctrine, which is a little bit, how to say, seems to be extreme in the sense that I'm familiar with the Anglo-Saxon doctrine of piercing the corporate veil, which only applies in certain specific circumstances where there are good reasons to pierce the veil. But it seems that you are saying that in Brazil this is a matter of practice, and it gives me the impression that the principle of limited liability doesn't exist any longer. Am I right? Is that, I would say, a wrong interpretation, or you actually mean something else?
Well, I told you that's not explained in Brazil, and the disregard doctrine, it's an institute that's useful. That's used when you have some specific moments to use it. The problem is the labor courts doesn't respect these moments. What the law says. The law says that if you use your company for other purpose than the core business, if you use the company for anything else than the core subject, you are under the disregard doctrine effects. The tax lawyers, the tax law says that if you interrupt for any reason the flow of negotiation, you are under the disregard doctrine. So this, unfortunately, is something that brings unsafety for investors, because even if you are a board member or a director, you are under the risks that the disregard doctrine can reach you. So it's a dangerous dispositive in Brazilian law. Unfortunately, it's not rare to see this kind of dispositive being used for the Brazilian courts.
There's a question right here. Stefano?
So, thank you for the microphone. My name is Dima Alexandrova, Bulgarian qualified lawyer and mediator. I have a question for Mrs. Nagla Nassar. I'm sorry if I'm mispronouncing your name.
It's excellent.
Okay, so my question was, don't you think that mediation can resolve the case where you're looking for where to sue and who to sue? And I was surprised to hear that mediation is limited in usage in the cases you addressed, because I just think that M&A guys are business-driven, commercially wise, and mediation can answer their needs as a procedure.
Okay. First, let's be honest about something. Mediation is a cultural thing. And that's why the Asian example is very successful, because the Asian culture is a non-confrontational culture. I am sure it will move gradually to the rest of the world when they become wiser. You know, I have been old enough to see Japanese people doing multi-billion transaction by a shake of hand. You know, it doesn't happen now, but in the 80s it did happen, until the Japanese got a few sore transactions, and then they were convinced with signing contracts. So let's distinguish between something, whether I support it, yes, I support it. It saves a lot of bad blood, okay? Whether it's practiced, no, it's not practiced, because the cultures outside the Asian ones are more confrontational to different degrees. In the specific case where I was an arbitrator, I wasn't a counsel, so I mean, I didn't even have to worry whether. First, there were no mediation clauses in the contract, so they didn't have to mediate. Secondly, maybe I didn't say it because of time, they tried to mediate, but there was a kind of fraud. This was an instant where one of the directors decided to take a project as is on the information and the contracts he saw, and copy it, cut and paste, and do it and apply for another license. In these cases, where there is bad intention and fraud, mediation doesn't serve a very big purpose. However, in cases where we are disagreeing on a price or disagreeing on a rep-on warranty, yes, of course. It saves us a lot of time, a lot of bad blood, okay? And we are just waiting to see that people get wiser and take the Asian model as an example. Thank you.
Additional questions? There's one over here.
Thank you very much. Not so much a question, perhaps, as just a quick comment. My name is Christopher Hedberg. I'm a legal counsel at the Arbitration Institute of the Stockholm Chamber of Commerce. And thank you very much to the panel for these interesting discussions. I especially found the comments made on arbitration clauses in M&A contracts and share purchase agreements quite interesting, and thought that it could be interesting to share my perspective, having worked as a transaction lawyer before joining the SSC, and especially the Swedish perspective, because I would say that in Sweden, both for domestic and international transactions, the market practice would be to include an arbitration clause. And this is also something that we can see somehow reflected in the SSC caseload, where we see quite a few post-M&A disputes. And I found the comment made interesting about this being due to a mistrust in domestic courts. I don't necessarily think that this is the case. I think it's more about the parties wanting confidential proceedings and a one-stop shop to settle post-M&A disputes. As for mediation, I would agree. I don't think it is as common in transactional disputes. So just sharing that perspective. Thank you.
Thank you very much. Any further questions or comments from the audience? Well, listen, we're at 10:15 or 10:18, something like that. Anyhow, we're very close to being on time. Let me ask my panel, any further comments you wish to make? Listen, we will be around for the coffee break. Is there a question there? Go on. Could we get him a... I'll grab this one. If it works.
This mediation, arbitration, litigation dilemma can be easily resolved by inserting a clause in the contract saying that you try mediation for 1 month, failing which you fall back to either arbitration or litigation. It has worked very well. Even in Spain, in the days there was not even mediation, we had introduced a mediation clause. And by selling 10 gasoline stations, it worked out real well, because if you go to the Spanish courts, it takes you 6 years. And with mediation, we had it resolved. Even with non-existing mediation in the country Spain, a Spanish professor went to London, got trained at CEDAR, came back, did a mediation, and resolved the problem for us within 6 months. So, applause for mediation, I would say.
Okay, thank you. No, I think companies, I've worked a lot as an in-house counsel, and I'm seeing companies move much more in the direction of mediation. At least giving it a try. They will. They may spend a little money in a month or two, but it sometimes is worth the effort. And the only other thing I was going to say, in lots of price adjustment clauses in M&A agreements, in share purchase agreements, you really, they really send the issue to an accounting firm, and then they have that accounting firm check with the accounting firm of the seller. So there is essentially a mediation between two accountants who are looking over the accounts before it gets into the real dispute resolution phase. So oftentimes those issues are dealt with at the accountancy level. So with that, I'm going to thank my panel. It was a pleasure working with you. Thank you to the audience. And as I said, we are around. And if you have any questions or want to discuss, we're available. And again, thank you very much.